Hello guys and welcome to my channel. I am Soumya and this is the lecture series on legal and constitutional history. This is the second lecture of the series in which I am discussing the topic Surat Settlement. In our last video, we saw how Queen Elizabeth I on December 31st, 1600 signed a charter, a document that changed the course of Indian history. The Charter of 1600 did three big things. Firstly, it created the company called as Governor and the Company of Merchants of London trading into the East Indies. Secondly, it created trade monopoly, exclusive trading rights with the East Indies. And thirdly, the Charter, for the very first time in English legal history, gave a private non-governmental body limited legislative powers, the power to make rules for its own servants and punish them. The charter also created a management structure for the company, which comprised of the court of directors and the court of proprietors. We also discussed the Charter of 1609, which extended the company's trading rights and made them indefinite. So, by 1609, the company had money, a monopoly, some legal powers on paper, but no fixed base in India. This is the gap that Surat fills. Now, let's understand why did the Britishers choose Surat. So, Surat on the Gujarat coast was already one of the busiest ports in the Mughal Empire, a trading hub for the Middle East and beyond, and the main embarkation point for Muslim pilgrims traveling to Mecca. So, good harbour, established merchant networks, direct access to the wealth of Mughal Empire. Commercially, it was the obvious choice. It was commercially and strategically very attractive. But there was a problem. The Portuguese had gotten there first, over a century ago, and they weren't interested in sharing. So, when the British East India Company sent its early ships, the Mughal Emperor Jahangir, under Portuguese pressure and influence, refused permission to set up a base. So the first proposal was rejected. Now the British needed to prove two things to the Mughal court. Firstly, that they could be useful trading partners, and secondly, that they could stand up to the Portuguese military. In 1612, a small English fleet defeated a much larger Portuguese naval force off the coast of Surat, a naval victory that changed the diplomatic equation entirely. So, following this, Captain Thomas Best secured Jahangir's permission, and in 1613 the British East India Company established its first permanent factory on Indian soil in Surat. Okay, let me quickly explain to you the meaning of factory here. The word factory here has nothing to do with manufacturing. The first year law students will get confused when they hear this word factory here. So it has got nothing to do with manufacturing here. A factory was simply a trading post, a fortified warehouse come office come residence where the company's agents, called as factors, lived and conducted business. So after Captain Thomas Best secured King's permission, that permission was a temporary one. Okay, It was a local permission, not a durable legal instrument. So, in the year 1615, King James I sent an ambassador, Sir Thomas Roe, to the Mughal court to formalize things, right? To formalize the arrangements at the Mughal court, King James I sent Sir Thomas Roe. Sir Thomas Roe spent several years at Jahangir's court and secured a firman. Farman is a written imperial decree. It is similar to a royal charter of India, right? So, the Farman confirmed and expanded the company's trading privileges and confirmed the British right to their own religion and their own legal system. So, this Farman secured two important rights for the Britishers. Okay. Firstly, the freedom to follow their own religious traditions and their own customs. This was the first right that they secured. Secondly, and more important for us law students, the right to resolve disputes among themselves through their own English tribunals rather than being subject to Mughal or Islamic law. Okay, so these are the two rights which the Britishers secured from King Jahangir. These two rights would define the entire colonial legal relationship for the next 300 years, right? So this is important. Now moving on to the administration of the Surat factory. Okay, factory, as I have already told you, is not a manufacturing unit as we understand it today. It is a trading post, warehouse, which is also used as residence, where the company's agents, who are called as factors, live and conduct the business. All right. So the administrative structure of the factory looked like this. At the top, in London, sat the court of directors. The governor and 24 directors, as we discussed in the Charter of 1600, elected annually by the shareholders, called as Court of Proprietors. Okay. The directors appointed a president, sometimes called as a governor, to head the Surat factory, and this president was assisted by a council of 4 to 5 members who were senior members. All right. Then below them, the company's staff were organized in a strict three-tier hierarchy. Firstly, there were writers, entry-level clerks under 5 years service, earning around £10 a year. Then the factors, promoted after 5 years, earning around £20 a year. And above them, senior factors and merchants, the most experienced servants at the top of the company's civil hierarchy. This hierarchy wasn't just a business organization chart, it was a civil service. It is important because this same hierarchy, writer, factor, and senior merchant, would later evolve into the ranks of the company. Okay, and then the crown's administration in India. So this is the origin where the structure of crown's administration in India evolved. Okay, now coming to the part which is which matters the most for a constitutional law study, how justice was actually administered. After the British East India Company entered India and they set up their base in Surat, they started with their activities and their business. And all of that is history, right? But let's be clear that here we are not discussing history. We are not just studying history, we are studying legal history. So, in every topic, I would like you to pay attention and focus more on the legal aspects of the things, right? Just like how under the topic Charter of 1600, the company secured an important power, which is limited legislative power, power to make rules for its servants and punish them. Okay, so that's an important legal aspect that we must know, because that's the origin where the company got its powers, legislative powers, right? Similarly, how the company secured from King Jahangir two rights, right? Two very important rights. One is to follow their own religion, and second, to solve their internal disputes by their own law and their own legal system. So that's a legal aspect that we must know and we must remember. Similarly, the administration of the company, the administrative structure, which later evolved into the administration of India by the crown, that again is important for us. And now this, the justice delivery system, right? So the Charter of 1600 had given the company limited legislative power to govern its own servants. At Surat, this expanded into something bigger, an actual functioning of informal judicial system. At that time, there was no permanent court building, no professional judges, right? Instead, and the council the president and the council doubled up as judicial authority, and they operated a dual legal system. Okay, so the president and the council took up the judicial authority and they applied a dual legal system which comprised of disputes among the British, okay, which were decided using English law, and disputes involving local Indians. So the disputes, the matters were categorized into these two categories: disputes among the British and disputes involving local Indians. And these two kinds of matters were dealt with separately and by different laws. Let's look at this dual legal system in more detail. So, firstly, disputes among the British. Which law governed? The English law governed the disputes among the British. However, disputes involving local Indians, the applicable law was the native law, and at that time, Islamic law was largely in practice. Okay, so this is the law that was applied. Then, authority deciding the cases. So, in case of disputes among the British, as I've already told you, the authority lied with the President and Council. In case of disputes involving Indians, the Qazis were the authority. Okay, Qazis were the authority who decided the cases. Then, with respect to serious crimes and death penalty, for disputes among the British, so serious crimes like murder, treason could carry the death penalty, but only after consultation with a jury. Okay, so death penalty was allowed, but with a consultation of jury. So there was a jury. But disputes involving local Indians, there was no jury, okay, and no concept of jury, and so nothing of that sort was followed. Then the role of jury, as I told you, in case of disputes among the British, for death penalty, the consultation of jury was required, was mandatory. However, in case of disputes involving local Indians, there was no requirement of jury. Lastly, position of traditional judicial officers. So, in case of disputes among the British, there were no traditional judicial officers in India for the British. So, this does not really apply. But in case of disputes involving local Indians, traditionally, Qazis, as I told you, were the judicial authority. But slowly with time, when the president and council started performing their judicial authority, these traditional Qazis, they lost their power, they lost their authority, and the president and the council assumed control over dispute resolution, even for the disputes involving local Indians. This was a big change, and we will study more about it in the upcoming videos. Lastly, let's discuss some criticisms of this early judicial system, because definitely this early judicial system was not the most uh, efficient or the effective one. So, what are the criticisms? What are the cracks in the system? Firstly, there were no permanent courts. Justice depended entirely on whoever happened to be the president and council that year. Okay, and so there was no institutional continuity. Secondly, no legal training. Okay, the merchants dispensing justice were traders, not lawyers. They had commercial experience, not legal expertise. So there were no lawyers involved. There was hardly any legal training given to these officers, right? So there was a huge lack of legal training. Then marginalization of local authority. By sidelining the traditional qazis and substituting company officials, the British didn't just create a parallel system, they actively weakened the existing local legal order without necessarily replacing it with anything more competent, right? Because this president and council who are now imparting justice were not at all legally trained, and they were just traders. So they were incompetent, right? And lastly, injustice towards Hindus. Since native law at Surat leaned heavily on Islamic legal categories suited to a Muslim majority trading elite, Hindu litigants, a large share of the local population, often found the system poorly adapted to their own customary law, leaving their interests inadequately protected. Okay, so that's how injustice was done towards the Hindus. So this was all about Surat settlement, and as I told you, we have to focus in every topic upon the legal aspects of things and try to understand how the law has evolved from then to now, right? Thank you for watching and stay connected.